Good morning. When the House rose last night, we were on the third reading, the Resource Management Duration of Consents Amendment Bill. We're on call number 3, Larne Farm.
Morena, and a holly jolly Merry Christmas morning we have this morning. Although we are in yesterday in this urgency, so it makes it a little bit weird. I wish I could say I was feeling the Christmas spirit today. I really wish I could. But the unfortunate thing, Mr. Speaker, is that we're starting this long day of urgency with nothing but a lump of democratic override, delayed environmental protections, and more pollution for Kiwis for Christmas. And I think the really disappointing thing that we heard throughout the committee stage was this constant denial and downplaying of the actual impacts of this bill. We heard from Minister Bishop, it's just a bill, it's only 5 clauses, it's not that complicated, and yet it was so clear throughout that the understanding of the very real implications is just completely absent. We don't know the actual implications when it comes to exactly how many consents, exactly what the environmental impacts will be of this delay. And there was a real incoherence and total lack of understanding within that about our existing resource management system and the people and the resources that go into actually making it work. We haven't seen that or heard that at all, or an acknowledgement of that. So I really want to take the time in the wrap-up of this third reading to acknowledge those people, particularly those council staff, but also those fantastic landowners and farmers who know and understand the importance of environmental protections and are actually getting on with the job despite anything that this government is doing. Now, we also heard from Minister Bishop that we're effectively doing to consents what we've already done with plans through the plan stop, relieving everyone of the burden of going through the motions with a major overhaul looming. But what that government is actually doing is leaving everyone else to continue to live with the burden of the impacts from the activities that happen in their communities. And a lot of these perhaps never should have been consented in the first place, or we're finally getting to the position where they would be renewed, where actual rules and regulations that exist within our district and our regional and our unitary plans would actually have some effect. And that's not just for a bureaucratic exercise, that's actually because we know we're losing biodiversity and we continue to lose it. We know we're losing, these last remaining dry land pockets of minute indigenous vegetation and kōwhai. These are the unseen impacts of this bill, and communities will now have to live with those impacts for another 5, maybe 6 years or longer. So what we find extremely disappointing with this government's pushing through the urgency of this bill is the power that is taken away from communities where in many instances, and particularly with iwi and hapu, we're finally about to be able to have a say, be able to contribute, whether that be through their own voice or through the voice of the democratically landed plans that actually wrote those rules and regulations that would have had impact. So instead we have this complete and utter overreach from this government, and it actually says everything it needs to say about the government, they seemingly have zero understanding of a duty of care that New Zealanders actually expect from government, no matter their stripes, of actually protecting Te Tai, our environment, and the value of local voice. You know, the government waxes lyrical about localism and then takes all the power away from those local communities. What's really damaging, and I'm hearing from the government that they want to hear something positive. Well, I think the positive thing that's going to come of this is that the communities across Aotearoa are seeing exactly what this government is about in terms of destruction of Te Tai, continued exploitation, and they're going to take the opportunity that the next year brings to vote this government out. That's the positive that I'm taking from this. Because no matter what this government does, for people, for farmers, for landowners who actually understand the world, the environment and their markets, they know that where we're going and where we're ultimately evolving as humanity on this planet is towards increased environmental protection and connection and understanding, not less. So this is a rallying call for everyone out there who rejects what this government are doing to get involved. So that's the positive that I want to take from today. They also say that this will give certainty to consent holders. So certainty to consent holders, councils and communities while the RMA is being replaced. And that is bang on, because it will certainly be the status quo continuing. It means certainty for those many communities across our country, places like Waimati, like Selwyn, like Kyle up in the north, that their water supply will continue to be undrinkable because of pollution, primarily from intensive agriculture, wastewater systems, stormwater systems. It's all one bundle. It will mean certainty this summer for New Zealanders who go out and think they can safely swim in their rivers and lakes, and they either get sick, or if they're, onto it enough to actually check, find that their local river, lake or beach is actually unswimmable. And it will certainly mean certainty for the declining trends that we know exist, with more species at risk of extinction, more communities struggling to pay for clean drinking water, and more valuable soil washed off our hillsides. Ultimately, this bill and the next steps that it provides for, this replacement of the RMA based on private property rights, will give New Zealanders certainty that soon enough, what someone wants to do with the land that they have the influence to make decisions on, whether they're the overpaid CEO of large milk processing companies or a mining executive or industrial farmer or, simply a neighbour, those private property rights will be more important than the activity that might have and the degradation and the exploitation that it will have on the communities and people downstream or in proximity to them. And that is absolutely not acceptable. If farming operators want to intensively farm, the nutrient pollution that leaches into the groundwater doesn't just remain there. It impacts everyone around them. It pollutes the groundwater. We know this. We know if someone strips the native forest on the hills of their property, the soil that washes down in the storms doesn't stop at the property boundary.
That's right.
It carries downstream, it carries on to communities with sometimes devastating impacts. We know that if landowners plant pine trees on steep land and clear fell them in one harvest, the logs and the soil don't respect property rights. They impact all of us. This bill is just one of the many government's short-sighted, ill-thought-out, destructive attacks on even the most basic protections that we have remaining. And it can be really hard within this to remember that a better future is possible, but we're staying focused and New Zealand should know that it is.
The Honourable Andrew Hogarth.
Thank you, Mr Speaker. Well, some good news. I just remember previous mentioned about can people swim. I just did a quick check. It's 28 degrees on the farm yesterday, I was told, and had a quick check of the Lawa site. And yep, daughters are free to go swimming in the river. It's all good, and it looked like the rest of the Manawatu was as well. So it's not all doom and gloom. Now, in terms of this bill, it's a very simple bill. We've got a fundamental change coming up with the RM system. We are completely changing it on its head. We are moving to a new system. It makes absolute sense that we take the current consent holders and transition them through into this new system. I don't know whether members have seen the various accounts of how much it is costing people to get a simple consent renewal, but that's tens of thousands of dollars, sometimes hundreds of thousands of dollars to go through this process, all for what? It's not making the environment any better, it's making lawyers richer, but it ain't doing much for the environment. So this just makes complete and utter sense. Member also mentioned about, the fantastic farmers that are out there. Well, these are the people I've been meeting. These are the people that are facing these huge costs. You don't believe me? Feel free to send me an email. I'll give you the names and addresses. You can go visit them yourself and see the absolute wrenching process they've had to go through, and absolutely fantastic farms they're running just to try and get a consent renewal to keep on doing exactly what they've been doing, and in many cases getting awards for it, getting A-grade reports. This bill just makes absolute sense, and I commend it to the House.
Jamie Arbuckle.
Thank you, Mr Speaker. I rise on behalf of New Zealand First to support the Resource Management Duration of Consents Amendment Bill. And in the first reading, the Honourable Mark Patterson, he mentioned what a big week this is for New Zealand's future, and it is a big week, and this is a part of that legislation that will make such a difference going into 2026. It is a turning point in this environmental legislation and renewing the law as we go forward. It's also taking a blowtorch to the red and green tape that we see that is holding up business in development within the country. But Mr Speaker, as we heard from the last speaker, it is a simple bill in the fact that it's a 2-year extension. It gives to the 31st of December 2027 till the RMA replacement legislation comes in. So what that does, Mr Speaker, is gives some certainty. It also helps around costs, so people aren't spending unforeseeable amounts of costs on the old broken RMA. And both sides of this House get up constantly and say how the RMA 1991 is broken. So why would we want to force people to go through that system if it's a broken system when we've got something better just on the horizon? That is the reason we give this extension here today. So the other thing, Mr Speaker, we hear too often from the opposition, from the other side of the House, that everyone seems in New Zealand that's got a resource consent for some reason is a villain. They're not. They are genuine people trying to get this economy moving and trying to grow the economy, and this side of the House is getting behind those businesses and supporting them. That side of the House is being unhelpful. They're adding cost and uncertainty by making them go through a broken system. They actually sound like the bureaucracy we're trying to get rid of, and that's the reason they'll still be in opposition in 2026 going into 2027. This opposition, they don't care, and we do care on this side of the House. We will grow the economy. This is a good piece of legislation, and I commend it to the House. Thank you.
Nā koe, Tipika.
Debbie Narawa Packer.
You know, the hardest thing is not just having this whole debate under urgency, but is also reconciling the myth plus the legend and a whole lot of Disney kōrero that's been going on in the last 12 hours. what it is that the biggest discussion here, the fundamental principle of what's going on is that there is an assumption that everyone that has a consent is best practicing, that they have best practicing environmental aspects to their business, to their thinking, to their culture, to their way of being. But that is not the case for many. For many, this bill has interrupted those who have survived Muriropatu, and we're expecting to have consents concluding and justice served. That is not what is happening here. In many situations, we have people who have been absolute great citizens of Aotearoa, who have honoured Te Tiriti, who have honoured settlements, and are protecting the awa, Waikato awa, who are concerned with the extraction that consents are doing. In many situations, these are great partnerships and great examples for Aotearoa to show those iwi, those hapu, those leaders of community Māori, that have gone and worked with their councils, that have gone and agreed on what can be the next movement within these consents, but they're no longer going to end. And that is the fundamental argument here. Not as that there are some good farmers, not as that there are some good practicing companies. The fact that the law was meant to protect us all. And by extending this, that has been taken off every other citizen who has absolute right to be able to conclude some poor practicing companies with really bad consents. That is what's at stake here. And I think, we need to go back and remind our whānau out there what consents look like. So what this government has said is that those who are not best practicing in polluting discharges, those who are not best practicing in industrial emissions, those who are not best practicing in stormwater runoffs, in land use, in coastal permits, in marine and coastal structures, those who are not best practicing in how they have applied their way into infrastructure projects are now given an extension. That's the debate. And we should all be applauding those who are best practicing. I certainly do, and have some great farming practices. We're all shareholders in PKW. Great farming practices, great land use. But not everyone is in that situation. And that's where this bill has desperately let down those communities. They have spent years, generations, protecting and expecting justice. And this government, in the interests which we continuously hear of economic development, has told those iwi, those hapu, those communities to go and forget what we had said we would do, which is treat all of Aotearoa equally, all of Aotearoa well and with justice. And that is not what this bill's doing. You can sit there and say it's complex, but the government can sit there and say it's complex, but it actually isn't. And why is everything that has to be about justice and economic development involve removing treaty relationships, involve removing the goodness and goodwill of iwi, involve taking out hapu? Why? Why can't we sit here and be a government and be a country and be a parliament that actually sits here and says, you're right, we honour Te Tiriti, we honour the great partnerships and the leadership that's happening out in the regions, that's happening out locally? No, why is it that everything that involves economic development, everything that involves cleaning things out in this government also means moving and sidelining Māori? Why? That is the problem here, is that this government has told all those waiting for generations across consecutive governments that you do not matter. Your consent issues do not matter. Your pollution issues do not matter. The fact that your wahitapu and your ability to want to develop does not matter. But by goodness, Māori, you matter when we want economic solutions. You matter when we want to make sure we have great partnerships with your dollars. But your principles and your values are thrown and sidelined by this government. That's what this bill is doing. And only this government will be able to confront the wrath of iwi and many who are having to unnecessarily spend their time in courts, undoing the damage that this has done. This was about honouring, and this government has honoured and sat there and agreed to every treaty settlement that has come through this House. Every treaty settlement. But in one swipe, under urgency, without even allowing them the dignity of a cordial or a conversation, you have decided to sideline their interests, sideline their intergenerational fights, sideline the fact that they have rights to be able to respect this taiao, and you have sidelined every other New Zealander that cares about the future of the mokopuna. Shame on this government. Kia ora.
Steve Abel
Thank you, Mr. Speaker. I would wish to remind the House and the member Jamie Arbuckle that it was his government that reinstated the RMA at the beginning of this term, after the previous government had created a whole new piece of environmental legislation, the Natural Built Environment Act. And so what was announced yesterday, Mr. Speaker, which is the reason for this piece of legislation before us today, was a radical inversion of the principle of the purpose of our primary legislative structure around the environment to be the protection of the environment. And this government has now created a situation where public officials will be spending the best part of 6 years rewriting environmental law because of the time spent by the previous government and the time spent by this government. How does that give certainty to the public or to industry? Minister Hoggard said that the new RMA, just now in his speech, completely turns it on its head. It does. It does, because it says that private capital should be the primary focus of our environmental regulatory system, not the environment. This law before us, this bill which extends the consents, like so many things that come to this House under this government, has had exceedingly little evaluation and scrutiny. There is no accompanying regulatory impact statement. The Ministry for Regulation has not exempted the proposal. The urgency with which this legislation was prepared did not allow time for a regulatory impact statement to be developed. Several thousand consents have recently expired or are likely to expire next year based on the limited data available, while we don't have exact data. The urgent timeframes for preparing this legislation have constrained the ability to undertake a broader analysis of the magnitude of the costs and the benefits. This is all in the Departmental Disclosure Statement, and the cost to the environment has certainly not been evaluated. Because this government fundamentally does not care about that cost. It is imposing on us a new, radically right-wing property rights above the commons, above the public good, above the founding principle on which our nation is based, Te Tiriti o Waitangi. It is opposing a new form of, actually, Mr. Bishop in his responses to questions last night used the term anarcho-libertarianism. In fact, the correct term for it is anarcho-capitalism, whereby you place private property at the centre of all considerations and you enforce the rights of private property. What's the problem with that, Mr. Speaker? Well, I tell you what the big problem with it is that the commons don't belong to anybody. The atmosphere doesn't belong to anybody. From the mountains to the sea, the rivers, the lakes, the aquifers, the oceans are not the possession of anybody. So how can you protect them through upholding private capital and property rights? You simply can't. The only thing you can do through that is allow the greater destruction and exploitation of them. If you've got the loot, you've got the right to pollute. And if you say that private property, which is capital, is a basis for a right, then the simple fact is if you've got more money, you've got more rights. And when Mr. Bishop gives the example of somebody putting a garage on the front of the house, that makes it sound like it's not actually about giving extraordinary extra rights to major corporations in this country. To say that if I'm going to tell Fonterra they can't put so much nitrates into our rivers, I better compensate them for it. I better compensate them for the regulator and the legislator doing their duty, which is protecting the commons from those who would destroy it, for the good of this generation and future generations. That is what environmental law should be based around. This extension is just a pathway to a Ozymandian hubris.
Katie Neiman.
Reverse everything over the last wee while. I think what is very important to say here is there is nothing more local than individuals in a community getting jobs done, doing the things that are very important for them. And I think that what has been said opposite is an insult to the council planners, consent planners that have put a huge deal of work into what's been done in the first place. This is making sure that every single one, and I said this last night, has certainty to keep going over the next 2 years while we go through the upcoming process. It is important, and I commend this bill to the House.
The Honourable Priyanka Radhakrishnan.
Thank you, Mr. Speaker. Quite a few things to traverse in the third reading of this bill today, and I want to make mention of some of the comments that members opposite have made, particularly Jamie Arbuckle, who claimed that those of us on this side who are speaking in opposition to this bill hold a view that those who hold resource consents are villains, and that is absolute nonsense, Mr. Speaker. There is nothing that is further from the truth, and I will lay out in my contribution to the third reading of this bill why that is so. Firstly, I will make the point, though, about the process that we've debated this bill under. It's been under urgency, all stages urgency, for a bill for which, while this may be a transitional bill, it provides, according to government members, some certainty for those who hold resource consents. But there was actually no need, firstly, for this bill at all if the government had got their act together and done a better job with the RM reform that they campaigned on. And secondly, I still don't understand, although we've gone through pretty much all stages of this bill, including a committee stage of this bill, why the secrecy for this bill? Is it just that the government couldn't get their act in order? Did they not foresee that this was going to happen? I mean, the bill, was introduced to the House a very short time frame before we actually debated this bill for the first time, to the point that when we read the bill and we clicked on the link to the departmental disclosure statement, the link was broken, and we couldn't actually get the DDS till we were in this House and we picked it up off the table. I mean, why this level of secrecy? We didn't know what the first bill was that they were going to introduce under urgency, and it was this one. A transitional bill that apparently just provides some certainty for resource consent holders. Did they not see that this was coming? And to my other point that I sort of laid out at the start, that there is actually no need for this bill at all, we spent a fair bit of time, Mr. Speaker, and we understand the need for faster consenting processes. We understood the fact that the RMA wasn't working in terms of consenting or protections for the environment. In fact, we repealed it, Mr. Speaker, and we replaced the RMA with two bills, which was the Natural and Built Environment Act and the Spatial Planning Act. Now, this government took office in 2023. One of the first things they did was to repeal, in December of 2023, those two bills. They have now taken 2 years to come up with two bills of their own, which to an extent mirror the legislation that Labour and government brought into play, that we had worked on over a considerable number of years. The main difference between their two bills and the ones that we introduced to replace the Resource Management Act is the emphasis on property rights. And that is the bit that is going to be problematic. But members can judge, members of the public can judge whether it warranted taking 2 years to repeal something and to replace it with legislation that is purely ideologically driven by that side of the House. Now, if they hadn't taken all that time to replace those two bills, they wouldn't have needed a transition bill, which is what we are debating under all stages urgency in this House today. And what is the problem with all stages urgency? Firstly, the lack of analysis. It is just bad lawmaking. And it is becoming a trend of this government to push through legislation. So members opposite heckle, Labour did it too. Not as much as this government is doing. And secondly, you do it when there's an absolute need to do it. That is why urgency is allowed in this House, not to push through things because a government is shambolic and couldn't get their act in order. Which is what we're seeing now. So it's bad lawmaking to keep pushing through bills that circumvent proper scrutiny and don't allow public consultation or public input here. And it's clearly stated in the departmental disclosure statement, once we got our hands on that, it says quite clearly here that there is no regulatory impact analysis because the urgency with which this legislation was prepared did not allow time for a RIS to be developed. There's also, under the section around the extent of impact analysis that is available, it clearly states here that several thousand consents have recently expired or are likely to expire next year based on the limited data available. That the Minister did lay out during the committee stage, that information is just not available apparently. But when it goes on to say that the analysis around the size of the potential costs and benefits of this legislation, no analysis around that. And again, it says here quite clearly that it's because of the urgent timeframes for preparing this legislation that have constrained the ability to undertake a broader analysis of the magnitude of costs and benefits with regard to this piece of legislation. I want to also lay out comments that have been made, Mr. Speaker, by environmental NGOs, most notably Forest and Bird, given that all of their voices were shut out of this process because there was no select committee stage to this, not even a short one, which the government could have done. Their concerns are around the blanket consent extensions that this bill provides for. And it's predicated on a few different things. One, of course, the environmental risk that it could pose. So when consents are extended without proper environmental assessments, it could pose a serious risk to biodiversity, to marine biodiversity, to water quality and taonga species. The other thing that it does is that it circumvents community and iwi or hapu input as well. Blanket extensions without thorough reconsenting or local review will bypass meaningful public input into this, and that undermines our democratic rights as a whole. Finally, what it also does, when you don't have a review process, you lock in outdated conditions as well. Things move on. You know, things change. This government is indeed stuck in time because science advances and progresses. Environmental conditions change. Climate impacts also mean that there will be potentially an impact on the environment. And if you have a review process for these resource consents baked in, it allows you to take those changes into account and then decide whether a consent should be reviewed or not. Forest and Bird also laid out some options for this government, which I was hoping to traverse in the committee stage, but unfortunately didn't get a call. And so I'll lay them out here. What this government could have chosen to do is to apply a risk-based review when it comes to consents. They could have chosen to enable low-risk consents to be progressed very quickly. They could have even allowed for higher-risk consents to be accelerated, but to bake in a review process with an allowance for community input there as well. They could have chosen to provide shorter extensions. A 6-year extension seems incredibly long. Given new consents can be issued from mid-2026, they could have actually picked a shorter time frame. And basically what the Minister said during committee stage was, oh, well, you know, we kind of had to pick a time frame and that's it. They could have also ensured that treaty obligations were met. Instead of just informing treaty partners, they could have consulted with treaty partners and not, therefore, potentially breached their treaty obligations. So, Mr. Speaker, there are a number of things that this government could have done better, but unfortunately, don't seem to be able to get their matters in hand. They could have foreseen that this was coming. They could have just stuck with the two bills that Labour worked on. That was actually essentially where they're getting to as well, because we did recognise the need for faster consents. However, we on this side of the House also prioritise protecting the environment. This government doesn't seem to feel the need to do that. We've seen numerous examples of how they continue to wage a war on the environment. This seems to be the next step. They've framed it as something that is transitional, something that is really nothing to see here, but they could have used this opportunity to do things better, and they chose not to, Madam Speaker, Mr. Speaker. And for all of those reasons that I've laid out, we do not support this bill.
Just point of order, Mr. Speaker.
Catherine,
point of order.
Honourable Williams.
Thank you very much, Mr. Speaker. I just want to draw your attention to the comment of Ryan Hamilton. He said during the speech of the conservation spokesperson of the Labour Party that she was not here. His exact quote was, "Because you weren't here." That is untrue and misleading. The reason why she didn't get a call was because the person in the chair at the time took a closure motion, and I'd like him to apologise.
Sorry, could you run that by me again?
No problem.
Yeah.
Mr. Speaker, it's both prohibited under the standing orders to comment on whether someone is in the House or not, and to say something which is untrue, whether that's in a speech or in a heckle. During the speech of my colleague, the Honourable Priyanka Radhakrishnan, Ryan Hamilton called out, "Because you weren't here," in response to her comment, "I didn't get a call in the committee stage, and so I will lay my argument out here." That is untrue, and it is unbecoming of a parliamentarian to comment in that way, and I'm asking you to ask him to withdraw and apologise.
Right, Mr Hamilton, that is actually correct. So I won't ask you to withdraw and apologise because I think it's. I'll put that as a warning broadly that we don't comment on people not being in the House. But I don't think it reaches the threshold of withdraw and apologise. So,
Speaker.
Catherine Wedd.
Look, I'd like to give the opposition a little wake-up call. When you run a business, you need certainty. When you export apples to the world, when you export red meat to the world, you need certainty. And this bill is about giving certainty to those consent holders, to those business owners, so they can create jobs and so they can grow our economy. I commend this bill to the House.
Speaker. 5 minute split call, the Honourable Damien O'Connor.
Mr Speaker, I'd suggest to that previous Speaker that she wakes up and comes into the real world. There's no certainty. There's not much certainty, and those people who will survive will be the ones who adapt to the changing circumstances internationally. Mr Speaker, this is a desperate bill, rushed through the House under urgency, and I'd suggest will be shown in history to be faulty. That's what usually happens. Mr Speaker, what we have here is rhetoric overtaking reality. We have a piece of legislation being passed through the House to deal with about 2,500 to 7,000. No one knows because there was no regulatory impact statement done. No idea of what is the issue here at stake. 2,500 to 7,000, possibly, of 200,000 consents being managed by councils across the nation. This Parliament often passes legislation to deal with a very small minority of consent holders or people who break the law. This is the case now. But be careful what you ask for. The Resource Management Act was an act passed by the national government. It's been amended, it's been chopped and changed, mainly added to, and all would agree that it's not perfect. But the rhetoric that we have from the people in the House here, blowtorch to red and green tape, turning it on its head. This is what we hear from the coalition partners. Well, go to the World Bank and ask, what is the reality for New Zealand businesses in this country? What are the hurdles to operating, the so-called certainty that the previous speaker referred to? Well, actually, we've been judged number one year after year to operate business internationally. It's easier in this country than just about every other country in the world. Now, can I say that of course some of the regulations are not perfect and we should continue to improve them. But if you get into the rhetoric that we hear from the other side of the House, they're going to throw it all out. We are already a laughing stock internationally for turning our back on our international obligations around climate change and around biodiversity. This will further add to the declining reputation that our ancestors have built up. Mr. Speaker, the vast majority, as I said before, of regulation and legislation that we pass here is for the minority of people. Deregulation is a rhetoric that we've heard from that side of the House time and time again. They, in government, deregulated the building industry. We ended up with leaky homes. They, in government, deregulated health and safety. We ended up with Pike River and too many people killed at work. Mr. Speaker, they think they're going to deregulate the resource management process. I'll tell you what's going to happen. I'll tell you what's going to happen is that we will have a trail of lawyers up and down this country working out whose property rights are paramount, whose property rights are more important, when one neighbour versus the other, when the council versus the private property owner. Oh, they're asking, how is this relevant to the bill? What this bill is rolling over consents on the basis that it will offer certainty. You're kidding yourselves. You are absolutely kidding yourselves. This will not offer certainty at all. What is certain is that we all collectively have some challenges moving forward. And indeed, unless we address those, the rhetoric coming from that side of the House will give people false hope that they can get on and do what they like without any regard for environmental impact or the neighbour's property rights, because your individual rights as a property owner will be paramount. That's what we have heard from speakers on that side of the House time and time again. Let's be honest, as a parliament, let's say that the original Resource Management Act passed by the National Party, amended many times and now under new proposals, is designed to balance property rights versus environmental responsibility. We in Labor support that approach, but the idea that property rights will roll right through environmental responsibility is both ridiculous, it will undermine our international reputation and should not be supported.
Grant McCallum.
The previous speaker talked about reality. Well, I'd like to give the opposition a lesson in reality. And the reality is simply this. I wish to commend the family, the Clark family, David and Jane, for having been brave enough to stand up and highlight the challenges that the previous regime was delivering for them, costing thousands of dollars and creating huge uncertainty for their family. And for that reason, I commend this bill to the House.
Arna Williams.
Mr. Speaker, thank you for the opportunity to talk in this final reading of the Resource Management Duration Consents Amendment Bill, a bill that was introduced yesterday to the House, and here we are. It will soon be law in mere minutes. That is the way our legislature has been designed. Many people, much smarter than me, have commented on it, but it does seem relevant to reflect on it at this point in the year, when we're at the end of a year where the government has used urgency over and over again. It is less common for all stages urgency to progress like this, and in a bill which itself removes public participation rights. So there is both the removal of public participation rights at the primary legislative stage, and then the ability of anyone who wants to comment on the resource consents extensions is also curtailed. There's some poetry in that, Mr. Speaker. But let me turn to this bill and what it does, because it was actually really helpful, and I want to thank the Minister for his engagement in a committee stage that did bring much of that to light. When the opposition finds on the table the only information that is provided to us in a regulatory impact statement that is 2 pages long and generally answers all questions with a simple no. We are reliant on the Minister to talk through some of the policy choices that he has made and his intentions behind those choices. None of those have been echoed in the speeches by government members in the first, second or third reading. And so it's useful for us to continue to record them here. If the policy intention of the Minister is to be taken at face value, it's about getting the balance right. It's not about continuing consents that have existed just for 2 years, because that is the fix in and of itself. This idea that 2-year extensions on consent has no impact isn't in fact what the Minister was contending at all. That a 2-year extension is a valuable property right bestowed on these people simply because they have stacked up first is something that he was trying to achieve. But it's important that we know what we're doing here, because that has an impact financially on the neighbours, on the people down the street, on the people downriver, on the people in a community if it is an air discharge. I want to say to the electorate MPs on the other side who are frustrated with opposition MPs raising these questions and pointing these things out. If any of you are electorate MPs who have been involved with communities who have brought to you petitions about the local dump discharging its odours next to the school, if any of you have been an electorate MP who has talked to a business owner who is worried about the business that is opening up down the street with a water take or a discharge, this is that. This is about those business owners, those neighbours, those people who come to you and they say genuinely, I'm trying to do absolutely everything right under the law. And I'm really worried about the person down the road who I think is taking too much, is in the 1980s was granted these rights and it doesn't fit with the character of the neighbourhood anymore. I want to live here undisturbed. I want my kids to be able to go to school down the road without air pollution in the community, because now this community has grown and there are more people here. This is that, right? We know that this is an extension of those rights for 2 years without any of those ability. That mum who sat in your office and raised with you this issue of the kids going to school next to the air discharge at the plant, which was built in the 1970s, this is about her. And this is the legislative answer to her, which says you have no say. You know that, right? And when she comes to you and you say as her electorate MP, I would love to help you. This is a legitimate concern. Good on you for going around your neighbours and getting a petition of 20 people. This is engaging with democracy. Good on you. As your electorate MP, that is my role. I will take this to Parliament. I don't necessarily agree with you, but I will raise it with ministers. This is that. This is no to that mum. This is no to those community groups that want to go to council and have a say on the water takes. This is no to the business owner downstream from those people who have water takes that were granted in the 1980s and are no longer appropriate because the environmental science has moved on and we know more about their uses. This bill does that, and there are trade-offs to be made here. But shouting down concerns that are being raised here about public participation is saying no to those people. And the choice that has been made here from a policy perspective is about whether the balance is right. And that comes down to what resource consents are for. And the resource consents that have a time on them are not land consents. We're not talking about the owners of most blocks of land, because those consents don't end. The consents that do end, Andy Foster, are water takes, they're irrigation takes, they're air discharges. They're the ones which do have a community impact. And the reason they have a timing on them is because people want to have a say on those. So these are the ones we are talking about. And when we're talking about the extensions for farmers, we are talking about the ones where there is legitimate community concerns, where we want to engage in a community dialogue about those. So there is a trade-off to be made here. And it was useful in the committee stage to tease out some of these issues. Issues like when you make planning rules changes in Auckland, you have a complicated web of different planning changes. They're called PC number. And in the case that occurred in November last year, Council adopted some new rules that were essentially given effect by planning changes that we made in this House, and all of a sudden, developers who were wanting to build 3-storey houses because they were relying on the MDRS, the medium density rules, couldn't build those anymore. We haven't solved that problem for them, and this bill could have done that. I put that to the Minister. He is working through that, but this is another missed opportunity and a reason why a rushed legislative process where people can't come along and have their say, they can't come to their local MP and say, hey, I'm a mum and dad developer because I've had this land for 10 years. It's now the right time in the market for me. I can get a builder cheaply. Husband can do some of it himself. We're really excited to build this 3-bedroom townhouse. No, it's this bill, Ryan Hamilton. Perhaps you could have been listening in the committee stage, which you were clearly in the entire time. The issue here is that when those developers weren't able to develop their land, this is not solving it for them, and this is not solving it for everyone who has issues with the timing involved in introducing this kind of reform. It's only dealing with those sorts of consents like water discharges, like air issues that have public participation in them, and it's just a blanket extension which creates an extended property right with no protections for community. In the least to say that this bill also absolutely limits the right of Māori participation in the extension of these, that we have moved on so far from the 1980s, and that should be progress we can all be proud of as New Zealanders, where the ability of iwi and hapu to make their views heard about the use of water, about the use of air, has changed. And that is generally, I think, everyone in this House would agree that that is a good thing. They are not able to do that. In some cases, they have been waiting 25 years, 30 years, 35 years to be able to have their say about these water takes, which were granted many years ago, before they were settled, before they had an office, before they were able to collectivise and have a say in the environmental planning regime. And they will not be able to do that now, not just for 2 years, but effectively until 2031. And that was an issue that we played out at the committee stage, we got to the bottom of. It was useful to really understand what this government is doing here, that those rights will be curtailed, that there has not been consultation with iwi, with hapu, with Māori affected landowners at all before the introduction of this bill. And one can only assume that the quick introduction, the lack of consultation with the opposition, and the way that now iwi, it is said, will be informed of this rather than consulted, is because the government feared the litigation risk because of this. And why is there litigation risk? It's because iwi want to have a say. They want to be at the table when it comes to matters of water and air, because they want to be able to be alongside government and local government and make those decisions as kaitiaki of their whenua. And that's something we should be all able to agree with, but that is not what's happening here. Finally, Mr. Speaker, I want to reflect on the difference in making a decision like this under all stages urgency and having it been through committee. We won't know how this affects people or who it affects or how many it affects until this law takes effect, but we all should. All of us who are elected MPs, who have water takes in our area, who have pollution discharges into our air, when you look up and you're an Auckland MP and you see the smoke in the columns going up, you should know that that has been extended, and you should find out what your community thinks, because that's your job and that's the decision we have made today.
I'll just say touche, Ms Williams. Ryan Hamilton.
Oh, thank you, Mr. Speaker. Look, I won't take too long. We were criticised for being rushed with this process and taking 2 years to build the RMA. And in that process, we've created this hybrid bill to, I guess, grandfather or piggyback or support those that are caught in between the legislation process, to carry them over and give them some security. We've heard all the scaremongering from the other side about treaty and rushed and all this stuff, but Mr. Speaker, this is pragmatic. New Zealand is watching, and I'm proud to be part of this once-in-a-generational change. I commend this bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā pōti whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Pōti whakahe.
Taku Te Wheres.
Ko tahi te pōti whakahe.
Mariamino Kapakingi.
1 vote opposed.
The ayes are 68, the noes are 55. The question is agreed.
Resource Management Duration of Consents Amendment Bill, third reading.
I move that the Emergency Management
The
Bill...
Honourable Mark Mitchell.
Thank you, Mr Speaker. I move that the Emergency Management Bill be now read a first time. I nominate the Governance and Administration Committee to consider the bill.
Was there a legislative statement there, Mr Mitchell?
The bill will replace the Civil Defence...
Mr Mitchell, was there a legislative statement? You were...
I present the legislative statement, Mr Speaker.
That legislative statement is published under the authority of the House and can be found on the Parliament website. Honourable Mark Mitchell.
This bill will replace the Civil Defence Emergency Management Act 2002 and make a number of changes which respond to the government inquiry into the response...
You're now required to finish moving the bill. Sorry, just to...
I move that the Emergency Management Bill be now read a first time. I nominate the Governance and Administration Committee to consider the bill.
Thank you.
The bill will replace the Civil Defence Emergency Management Act 2002 with a number of changes which respond to the government inquiry into the response to the North Island severe weather events of early 2023. Mr Speaker, I want to acknowledge the work done by colleagues across Parliament who also recognise the need to strengthen our emergency management system. There are two areas, Mr Speaker, that I feel are really important for us as a Parliament to work together on. One is national security and the other is emergency management. And firstly, I want to acknowledge the outstanding NEMA team, right from the leadership through to our policy team, who have worked very long hours, burning the midnight oil to work on this bill and bring an outstanding bill to the House, right through to our people that deploy, that provide advice, that work on education and man our information centre 24 hours a day, keeping us updated with information as it unfolds around our country. We are a country that will continue to be hit with weather events. I want to acknowledge the mayors, the chief executives and our civil defence controllers and all the stakeholders who have been engaged with us on the development of this bill. I want to acknowledge them and their hard work and their engagement. I want to acknowledge Camilla Bellich and Francisco Hernandez for the work that they have done with us on this bill in a very bipartisan way. Camilla, I want to make a special mention to you. Not only has she worked very closely with me on this bill, she is on the ground at several of the events that I've been to that have been local states of emergency, and I appreciate your engagement because you know, I think that in terms of emergency management we all need to be working together on that, and I know that's appreciated when you're on the ground also. I want to acknowledge the previous ministers, Kieran McAnulty, who provided me with a seamless handover takeover when I took over from him. Kerry Allen, who continues to work in emergency management through the Iwi Leaders Forum and has worked very well with us, and Marama Royal. I want to acknowledge them. Penny Henry is the previous minister. Chris Farfoy, who I've done a lot of work with, who now has a leadership role with our insurance agents companies and has done a lot of work with me. Nathan Guy, Jerry Brownlee. Can I acknowledge Jerry Brownlee, who has given me a lot of extremely useful advice, especially around recovery. I don't know if there's another minister that has been in this House in our recent history that has had to deal and do the heavy lifting around recovery, and I want to thank him and acknowledge his outstanding guidance advice for me in this role. And finally, I want to acknowledge Nikki Kay, and I'll finish there, but I wanted to mention Nikki Kay because I think the whole House would agree that you would not have found a more passionate Minister of Civil Defence than Nikki Kay, and the astounding amount of work that she got through in the 3 years that she was Minister. Mr Speaker, the previous Emergency Management Bill proposed a range of sensible changes that we have taken forward, but it predated the inquiry's final report, so it didn't go far enough to address lessons from Cyclone Gabriel and the Auckland anniversary floods. The frequency, complexity and consequences of recent emergencies have highlighted the importance of updating the legislation to improve how we manage risks, prepare for, respond to and recover from emergencies, and empower and support communities. New Zealand's approach to emergency management is based on 3 key principles. First, we need to pay attention to all hazards, natural and man-made. Second, we need an end-to-end approach to managing the risks from those hazards. That means taking action across the 4 Rs: risk reduction, readiness, response and recovery. Third, all parts of society have a role to play in emergency management. Risks should be managed by those who are best placed to manage them. This was an intent of the CDM Act, and this bill follows the same philosophy, but the inquiry and other reviews have made it clear that New Zealand has not achieved what Parliament envisaged when the Act was passed in 2002. The inquiry, as well as submissions on the previous bill, informed our reform objectives and proposals, which were publicly consulted on earlier this year. That consultation has led to over 20 substantive changes being made through this bill, in addition to a general overhaul to modernise the Act. The majority of submitters agreed to our reform objectives, which are to strengthen the role of the communities in iwi, Māori and emergency management, provide for clear responsibilities and accountabilities at the national, regional and local levels, enable a higher minimum standard of emergency management, minimise disruption to essential services, and ensure agencies have the tools to do their jobs effectively when an emergency happens. I'd like to touch on some of the most significant changes the bill will make to deliver on those objectives and make a real difference on the ground. To strengthen the role of communications and iwi, Māori and emergency management, the bill provides membership roles for iwi, Māori, rural communities and the wider community on coordinating executive groups. These groups are currently made up of local authority chief executives and senior representatives from emergency services in each area. They are responsible for advising the local political level of emergency management. Having a seat at the table will give iwi, Māori, rural communities and the wider community a direct role in informing what their Emergency Management Committee does to reduce risk, get ready for emergencies and respond and recover when they happen. The bill also requires engagement with iwi, Māori and the wider community, particularly those who may be disproportionately affected by emergencies, whether they have existing vulnerabilities or different needs that don't suit a one-size-fits-all approach. Emergency Management Committees and the Director-General of Emergency Management will be required to identify these groups, such as disabled people, seniors and our culturally and linguistically diverse communities, and engage with their representatives when developing regional and national emergency management plans. The bill also provides for more clarity about roles and responsibilities at the national, regional and local levels of emergency management to ensure faster decisions are made by the right people. The need for role clarity has come up in the inquiry and other reviews, and I've seen it firsthand at emergency events over the past 2 years. It is absolutely critical that responsibilities and accountabilities are clear. Any confusion about who is making decisions causes unacceptable delays during a response. Local government has key roles in emergency management. The vast majority of emergencies play out at a local level, and other legislation gives local authorities many of the levers to manage hazard risks. Councils know their own communities best when an emergency cuts communication and knocks roads out of action. Local resources may be all that's available to respond for the first few hours. But the bill retains committees of the councils in each region. Each exists to provide economies of scale and enable regional coordination of emergency management. However, it puts more emphasis on councils' individuals' responsibilities by creating specific roles for regional emergency committees and their local authority members, making mayors primarily responsible for declaring states of local emergency and recovery transition periods within their own districts, and requiring every territorial authority to have a district controller and district recovery manager with a clear line of accountability to the council's chief executive. Given territorial authority chief executives an explicit mandate to coordinate resources provided by other agencies in the lead up to an emergency and over the long-term recovery is essential. The bill also addresses current ambiguity around who is in charge during an emergency by formalising and clarifying the concept of lead agencies as the central government agencies responsible for responding to emergencies caused by specific hazards. Lead agencies will be required to keep the Director-General of Emergency Management informed of situations where there is or may be an imminent threat to an emergency. In turn, the bill places a duty on the Director-General to inform the Minister about such situations. Timely and reliable information is a key part to determining whether a situation may meet the threshold for a response under the bill and provides a better chance of addressing the situation before it escalates. Regional emergency management plans are key instruments for driving action across the 4 Rs at the local government level. They identify the hazards and risks to be managed by each emergency management committee and set out the policies, projects and other necessary measures to manage them. These measures could include things like identifying bylaw changes, setting requirements on each of the committee's councils to build their response capability, or agreeing to progress joint risk reduction initiatives. Mr Speaker, I wanted to finish my speech today in an acknowledgement to an outstanding NEMA manager in the Christchurch area, Rochelle Faimalo. Rochelle passed away peacefully on the 13th of August this year, wife to Joe, mother to Azure, Zion, Quest and stepmum to Georgia. She quite simply she typified the quality of the people, the qualities that our emergency management people right across the country bring to that role. I met her during the Port Hill fires, where she played a critical leadership role. This will be the first Christmas that their kids don't have their mum. She was 40 years old. She was a much loved member of the NEMA team, and she was very passionate about this bill coming to the House, which she was briefing mayors on right up till June. So I wanted to acknowledge her, and I wanted to let the family know that we're thinking of them during the Christmas break. Thank you.
The question is that the motion be agreed to.
Mr Speaker.
Camilla Bellich.
Thank you, Mr Speaker. And I just want to acknowledge the contribution of the Minister and also echo our condolences to Rochelle's family. I know that the work on the Port Hills fire was really exceptional, and as the Minister will know, or anyone who's worked in this area, the people who are involved in emergency management around New Zealand are really exceptional people. Often it's a career that they end up being in for most of their lives, and it's not because of anything that they personally gain from it. It's from really a feeling of service and contribution to New Zealand, and so we're very grateful to them, and it's always sad to hear of one of our colleagues who has departed. So I want to acknowledge that family. Also want to acknowledge and reiterate the acknowledgement that the Minister made of people who have been involved in this bill. This bill is something that has gone over a series of governments, and that is the nature of emergency management. Emergency management is something that is exceptionally important to New Zealand and exceptionally important to our communities, and we never know who's going to be in government when an emergency strikes, and all that we can hope on either side of the House is that we can do everything that we can and that we have the best processes in place. And so this is something that is a genuine area, I think, of bipartisanship, and something that we on the side of the House and in the Labour Party take very seriously and have done when we've been lucky enough to hold those ministerial portfolios as well. And I know many of those previous ministers hold a very lot of interest still in this portfolio because of the importance that it has to New Zealand and to their communities. So I want to acknowledge the Minister for your work here as well, and also your team, especially Bailey in your office, who works very hard to make sure that we're all aware across the House of emergencies when they happen to. And I think that kind of approach is really what this bill is meant to legislate for. It's much more of a all of government rather than little sectors working on their own. So this is an important bill, and it's kind of the antithesis really to the previous bill we were discussing, Mr Speaker. This bill has really had its genesis in changes that were seen to be needed in the 2002 Act. There's a consensus, I think, from everyone that piece of legislation is no longer fit for purpose anymore in New Zealand, and various governments have, and there's been so many reviews, and there've been various governments have looked into trying to amend this. And I suppose the issue that we have is we keep having emergencies, and we keep realising that there are issues in our system, and I think it's important to acknowledge that we will never have a perfect emergency management system, and we will never be able to do everything. But that doesn't mean that we shouldn't do everything that we can, and that we shouldn't learn every lesson that we can in order to be better prepared. So when we were in government, Labour was in government, we did introduce a bill, and we're happy to see that a lot of the sensible, pragmatic suggestions that were in that bill have been carried through into this new piece of legislation as well. And the big thing that happened in between that introduction of that bill was the North Island weather events. A significant event for New Zealand. I want to acknowledge the 15 people who lost their lives in those very sad events, including children. I think it's couldn't be more serious that we get this system right, and certainly we will not stand in the way of making sure that these changes are implemented as soon as they can be, and so it's timely to see this introduced. We had a slightly different approach, it's fair to say, at Select Committee when we saw the report into the government inquiry into the North Island weather events. We thought maybe we could amend the existing bill and that would be faster. The government took a different view. That's their call. That was not something we agreed with at the time, but I think, as you could have heard through the Minister's reflections, we tried to work very constructively with that decision. And as chair of the committee where this bill will go, definitely will be taking the scrutiny of this bill very seriously and making sure that we put forward the best possible bill to the House in order for this to be enacted, hopefully as soon as possible. I don't think we will ever have a perfect piece of legislation, but we certainly must implement the lessons that we learnt from that government inquiry. That government inquiry included at least six separate reviews and also several other studies into what was happening in our emergency management system. So it's really imperative now that we do implement this. This has been well thought through. We're talking about regulatory impact statements. This is the regulatory impact statement on this bill. Extremely long, extremely thorough, extremely well thought through. This has had a previous Select Committee process on the last bill. It's had a initial consultation process from when the roadmap was set out by this government. It's had significant amounts of submissions from the public already, and so and then I understand it will go through a full Select Committee process as well. So this is something that the full democratic parliamentary process and all of the tools we have in relation to looking at the quality of our legislation have been utilised, and I want to commend the government for that. And it really should mean that there hopefully won't be any barriers to this bill being passed and being legislated for. I wanted to mention an important area which I think is reflected still in this bill, but is a bit of a difference from the previous bill brought in under the Labour government, and that's the role of iwi Māori in emergency management. We have seen it again and again, and one of the key findings from the government inquiry into the North Island weather events was that every time there is an emergency situation in New Zealand, whether they're asked to or not, whether they're at the table or not, iwi Māori marae step up in emergency situations. They take care of the people, they house people, they feed people. They have been taking on this role for generations, and whatever the legislation says, that's not going to change the manaakitanga and emergencies that iwi Māori have. And my colleague Kushla Tangiru Manuel took me up to Tairāwhiti, and I met some of those very people who took on that role during Cyclone Gabriel. So it's really important that that is acknowledged. The current legislation does not acknowledge that at all. This legislation does have a seat for iwi Māori at the Committee on Emergency Management Group, I think, the CARE group. That is something that we very much support, and I should note that it's not just one seat, it's one or more seats, so it depends on the different area as to whether more people should be involved. And there are also another couple of areas where iwi Māori can also participate and through being consulted as well. We had suggested a National Māori Emergency Management Advisory Group that hasn't been taken forward in this piece of legislation. From our perspective, that's regretful, but at the same time we see that there has been a concerted effort to improve the status quo, which is nothing at all at the moment, by the government and the minister, and want to acknowledge that, and also the significant treaty analysis that's been involved in the regulatory impact statement, and the intention of recognising what was in the government's report into the North Island weather events and making sure that there is recognition for that key role that iwi Māori play in our emergencies in New Zealand, and the fact that they have a right to have a seat at the table when decisions are made. So this bill is an improvement, and we do support that, so thank you to the Minister for taking that forward. There are other things in this bill which are significant changes. There are changes to ministerial powers, there are changes in relation to information sharing, and I should acknowledge as well, one of the benefits, although we didn't support the bill being discharged at the time, has been that the issues that we've seen in very recent events have been incorporated into this bill. And so I think that is a benefit. So one of those things is information sharing. There have been issues in recent events where information hasn't been shared in the way that it could most usefully be shared in order to assist the emergency management response. So I think that is a very good change as well. There's also, as the Minister said, changes around decision making. We know that it's really clear that there should be a really clear decision making process in emergencies. That hasn't been as clear as it should be under the current legislation. I think this legislation will improve that as well. So that is something that we definitely support. The situation in emergency management in New Zealand is that we need to take seriously the fact that, as the Minister often says and is recorded in the government's report, which this bill is really based on, is the fact that we do have the second most at-risk country in the world, and we are one of the developed countries with the most at-risk profile in the world. That means that we should be, in theory, the best at the world at emergency management, and I'm sure that is a desire shared across the House, that we need to do whatever it takes to do everything we absolutely can to ensure that emergencies, when they do occur, are run with the best available information, with the best systems. We know we have the best people, so it's just about utilising that collective information to do the things that we know will assist in the response. So I thank the House and this government and previous governments for the work on this bill, and I commend it to the House.
Just before I take the next call, just to acknowledge we did have an error with the clocks. First reading speeches after the Minister speaks are 5-minute calls. So from now on there will be 5-minute calls. I'll take the next call.
Thank you.
Francisco Hernandez.
Thank you, Mr. Speaker. I rise to speak in support of this bill, and I wanted to thank the Minister for his leadership and engagement on this. We know that in this portfolio you've been willing to make some hard but not so popular calls, so we do think that is a mark of leadership. And we also wanted to echo the condolences you've expressed to the families of Rochelle and the thanks that you've expressed to the emergency management workers all around the country. The Greens are always uncomfortable supporting any legislation under urgency, but I've been assured by the Minister that it will go through the full select committee process, so that's assured us. And I also appreciate my colleagues across the House and the cross-party nature of the way that we engage in emergency management. I always appreciate everyone's passion and engagement at the Government's Governance and Administration Committee, ably chaired by Camilla Bellich, when the topic of emergency management comes through. Everyone's passion for emergency management and a genuine desire to serve the country really comes through in those discussions. I mean, I think sometimes, Mr. Speaker, when we scream at each other across the chamber like animals, we lose sight of the fact that, everyone here is like intelligent adults that are doing their best to serve the country, and that does come through in those select committee discussions. And look, it does show what we can do when we work in a cross-party way. We can make good law and we can go through full select committee process. And while legislation of this is really welcome, we do need to actually address some of the drivers of the emergency management events that are increasingly occurring. Since 2023, New Zealand has been, either nationally or locally, in some state of emergency for 224 days. Every single one of these days has been due to a fire, coastal hazard, or severe weather or flooding. Most of these events, Mr. Speaker, are exacerbated by the impacts of climate change. Every single greenhouse gas we emit contributes to heating up our atmosphere, and every single fraction of a degree exacerbates and amplifies the impacts. Now, in the same urgency block that we are passing this needed and necessary legislation with cross-party support, this government has also introduced a bill that would gut the Climate Change Response Act by weakening our emissions reduction targets, watering down the Independent Climate Change Commission, and gutting our emissions trading scheme. It's a little bit like increasing the funding to the fire service, something that's urgent and necessary, by the way. At the same time, you're handing out fire starters. So, look, we do support this bill. It is a good and necessary bill, and we support in particular the increased coordination between local and central government that this bill enables, the requirements for Lifeline services to contribute to emergency management plans, the increased protection for animals in emergency management situations, the increased oversight for emergency management powers, and the increased role in increasing the role at the table for iwi and Māori. But there are things that we think that this bill could go further on, and these are the things that we will push during the select committee stage. And we do know, as my colleague Camilla Bellich has said, that the original emergency management bill that was introduced by the then Labour government had stronger provisions for working with iwi Māori. We also want to ensure that disabled people are included in the emergency management planning, and we will continue to push for greater integration with climate change adaptation frameworks, because the risk reduction aspect is really complemented by efforts to ensure that they're being aligned with climate adaptation efforts. And outside of the legislative process, we will continue to fight for what we always have fought for: fair funding for workers and the emergency management frontline, at the climate emergency management frontline, like firefighters, so that they can have fair pay and conditions and safe equipment. So I wanted to close by thanking the emergency management workers, not only at NEMA, not only at the people working across the different councils, but also the people at the the front line at the emergency management response, whether they be police, whether they be ambulance workers, nurses, people who are really dealing with the actual frontline impacts of the emergency management events. And I really wanted to thank in particular to the firefighters who came to talk to us at Parliament Forecourt last night. We do stand with you and all the other emergency management workers around this country. And I hope that you can see with the cross-party support that this bill is getting that we do support emergency management across the House in this country. Kia ora.
Mr Speaker.
Laura McClure.
Thank you, Mr Speaker. I rise in support of this piece of legislation. I also want to acknowledge the Minister and his work, and the opposition members for their work in this this reform that we greatly need. I also want to acknowledge Rochelle and her family, being from Christchurch. I did not know her personally, but I do have quite a few friends and family that had worked with her. Some of you may know or may not know that before I became an MP, I actually worked in this space for the last 15 to 20 years. I'd been doing emergency response planning, mostly in the evacuation side of things, but I'd been working quite a lot out there with our communities, with our councils, with our iwi around improving the systems that we have. And time after, we would often hear that when disaster strikes, there was a lot of confusion, a lot of bureaucracy, a lot of red tape around what could and could not be done. What I'm really happy to see is that this is enabling more of a community-led approach. And I think that's a really important thing, because we all know that communities know the person to get on the phone and call up when they need a generator. We know that central government rolling in to do that job is not going to have the same effect. So I think that this bill's a really great start, and it's heading in the right direction to empower those communities. We also know that failure to prepare for a disaster means that we prepare to fail ourselves. And that is something that I've always said to people, and it's highly important that we actually go into the preparation a lot more. And I hope to see that these established groups really do get into the preparation and actually go through some of the scenarios. I know that the former member, the member across the other side of the House, talked about we could have any system and it would never be perfect, and that is actually true, because you can never prepare for some things. But what you can do is you can make sure that people know their roles and they know who to call and they know where to go. And that has to be led from the community. I do have concerns with the bill that the community part of it doesn't include our NGOs, our other community organisations and our other groups that are actually on the ground as well. And I think that we need to consider that, and I really look to those, particularly the councils that are going to be setting up these groups, to think about the other people that are often involved in a disaster, and also that recovery phase as well, because we want to decentralise this process as much as possible to empower those communities to do the right things. We also have a bit of a concern about the Maruranga Māori and the tikanga into the committees. I think while we definitely need local voices and local iwi, we have to have that. It's really important. But we don't want, somebody coming in from central government just saying, oh, I know the tikanga, that this is how it's going to be. So I really want to make sure that when the select committee goes through this, that they actually consider that these are locals, these are people from the marae that are involved, because that's how we're going to drive the best outcomes. So thank you, Mr. Speaker. I commend this bill to the House, and I'd like to see where it goes in the future.
Andy Foster. Thank you, Mr. Speaker. Look, I rise on behalf of New Zealand First and also as a member of the Governance and Administration Select Committee. Looking forward to considering this bill later on. Just want to start by saying thank you to Minister Mark Mitchell, both for the work that's gone into this, but also for the way in which you've engaged with the Select Committee every time you've come along. It's been a very open conversation, and I think that's great. So really appreciate that. Mr. Speaker, it was Sir Humphrey Appleby who said that civil defence is a joke. Everyone knows that civil defence is a joke. I don't think he'd have given that advice if he'd been living in New Zealand. And I look at what the information which many of you will have seen that NEMA has given us. We have been in New Zealand since 2016. There have been 87 local and 2 national states of emergencies declared. Total 559 days, at least at the time that this was published. That's equivalent to 1 day every week for that 10 years that somewhere in the country, or the whole country, was under a state of emergency. So it is a big deal in New Zealand. And looking forward, NEMA talk about the likelihood of serious and significant events. And you look at this and say, there are some certainties in life. There's death, there's taxes. And I'll tell you what, in New Zealand, there is emergency, because there will be some. I mean, even if you look at one particular one, which is the AF8 situation, next 50 years, 75% chance of that happening. That's not quite certain, but it's getting right up there. So being prepared, being able to respond to emergency is absolutely essential. This emergency management bill has been long awaited. It's been great to see a lot of engagement. If we did lots of engagement before all pieces of legislation, that'd be a really good thing, because there'd be much better legislation for it. And I'm sure that this will improve the legislation that we've got in front of us at the moment, the level of public input. It's important, Mr. Speaker, I think that this bill delivers all that we need in terms of emergency management. I don't know how hard it is to get a legislative slot, but I don't imagine it's easy. So this is the shot that we have to get emergency management right in this country. Mr. Speaker, the bill talks about 3 things: taking an end-to-end approach, come back to that in just a second, considering all hazards, and all parts of society playing a role. And we've had a lot already, the discussion about the importance of community, the importance of iwi being involved in emergency management and emergency response. We also talk, Mr. Speaker, about the 4 R's: reduction, readiness. We can't avoid risk, but we can consistently work to reduce that risk. There's also response and recovery. And the danger, I think, Mr. Speaker, in these things is we focus too much on the response and recovery and not necessarily enough on making sure that we don't have the problem in the first place. So 3 quick lessons that we've had with the engagement, particularly with you, Minister, and our engagement with NEMA. The first one of them is that we need to stop reinventing the wheel with every single different event. Every event that we have, it's who do we need to get involved in this event to try and respond to it. We've got to do better than that and be switched on right from the start. That's the kind of bureaucracy, I think, that we've just heard about from the previous speaker. Secondly, we've got to stop building dumb things in dumb places. And I just want to think about the Auckland situation where we've had to change the planning laws so that we didn't put 3,000 plus homes in a place which was subject to flooding. So we stopped building dumb things in dumb places, and you get a lot of support from that from the insurance industry and our Hazards Commission. But also the question is, what is the role of NEMA in saying stop building dumb things in dumb places? Because I think that they should have a role in doing that. And the third one is adaptation. We've already heard a little bit about adaptation, but I just want to call out one particular thing. We were at a meeting in Hamilton not that long ago, middle of the year I think it was, and Shane Jones was talking to that meeting, talking about investment in the regions, and somebody stood up unprompted and said, look, thank you very much for the work that was done under the Provincial Growth Fund in protecting Taradale. And what he said is that the floodwaters under Cyclone Gabrielle got within a few feet of the top of that flood bank. If they got over that flood bank, or that flood bank had not been there, just think of the loss of property and, worse, the loss of life that would have happened. So preparedness, really, really important. Mr. Speaker, just to finish off, there are a lot of aspects to emergency management, and at a recent visit to the West Coast, they're very anxious about emergency management. I mentioned the AF8 situation, the availability of Bailey bridges, fuel and equipment, how we manage events and tunnels. Visited the mines rescue, and they raised issues not only of those tunnels that they have there, but also of road and rail tunnels. So there's a lot that goes into preparing for emergencies and then to responding to them. Mr. Speaker, looking forward to Governance Administration hearing submissions and considering the bill, and I commend the bill to the House. Thank you.
Tēnā rā koe te pika o te rā, tēnā rā tātou e te whare. E tū ana te Pāti Māori ki te tautoko i tēnei pire, waihoki ki te mihi atu ki te minita, kia koe Mark me o mahi, me o kaimahi roto i tēnei o ngā pire, waihoki ki ngā kaimahi putanoi i te motu, kua rau o rātou ringa raupa ki tēnei momo mahi i roto i ngā take āhuatanga o te motu me ngā huarere o te wā. So Te Pāti Māori supports this bill, and I just want to extend our mihi to the Minister, Mark, and also the condolences to the whānau who have lost a great wahine, and also acknowledging all the kaimahi within the emergency response team throughout the country. Sorry. This bill implements parts of the government's response to the 2023 inquiry into North Island severe weather events, finding that the current emergency management system was not fit for purpose and lacks the capacity or capability to deal with the significant emergencies affecting many regions. Thank you very much. Many regions at once. The inquiry also underscored the fact that Aotearoa has not achieved the whole of society approach to emergency management that Parliament envisioned when the CDEM Act was passed in 2002. I was born that year. A point solely understood by marae throughout the country. Iwi and Māori communities may be offered seats on committees and involvement in emergency responses that they would have let out anyway, because iwi and Māori don't sit around waiting for somebody else during and after a disaster. Rather, iwi and Māori choose to lead together when no one else will and can. Iwi, hapu and marae often place themselves forward as bastions of protection and manaakitanga to all communities affected. Tikanga steps forward where government legislation is inadequate. Iwi and hapu step forward where government agencies and authorities do not know where to look, who to speak to, or how to help. These acts of manaakitanga and rangatiratanga rang true during the Christchurch earthquakes and later the Kaikoura earthquake. More recently, the profound role of iwi Māori was demonstrated further during the Edgecombe floods and the Whakaari White Island disaster and Cyclone Gabrielle. E te pika, it was the late Dr. Ranginui Walker who said this: the marae is the focal point of Māori culture and communal activities, but the contemporary history lesson here is that the marae are often the focal point of emergency management and communal uplift. The marae is not only, as Dr. Ranginui puts, is a place to stand for Māori people, it is often a place of refuge and aroha for all people who enter its gates. And deeply held notions of mana and good faith towards all people who make up the diverse communities. Maraes are not businesses, and most don't have regular income and resources to support their functioning. So at times I must acknowledge the PGF fund that many marae have had across the country. And yet they are relied upon heavily by both governments and the public to provide support and relief despite the taxpayer-funded role and obligations of authorities. I might also just, while I've got the last minute, want to shed light on some of the young rangatahi Māori who have used their studies to contribute to their To Taiao, climate resilience and also their maraes, I want to acknowledge one person, Haukapua Nui Verko, who has used his PhD to future planning all maraes across the country and how we can better use our infrastructure of maraes because majority of our maraes are actually close to wetlands and are predominantly exposed to flooding. And that would be a great person to have on the future Māori Advisory Committee. Nō reira, tēnā rā tātou i te whika.
Tim Costello.
Merry Christmas, Mr. Speaker. Our philosophy for civil defence, emergency management in New Zealand has always been one of everyone in the community has a role to play. A small nation, we rely on each other. And this bill formalises that, whether it's in bringing in iwi, rural communities, these groups that have people, they have manpower, they have infrastructure, not just marae, they have machinery. And I think that's a great thing. I commend the bill to the House.
Le Maunga Lilia Sosene.
Well, thank you, Mr. Speaker. I rise to take a call on the Emergency Management Bill. And in particular, I would like to acknowledge the Minister, but also my colleague, Camilla Balich, who is the Chair of the Governance Administration. And I'm really pleased that I'm a member of the Governance Administration because we will be scrutinising and looking at the bill when it gets to Select Committee. Mr. Speaker, I do want to just mention that Labor did have an emergency management bill. The bill had been, in our version, through extensive policy development and Select Committee process, and progress could have been faster. However, we are now at this point. I want to acknowledge, as Minister highlighted, a family who have lost their loved one. We want to pass on our condolences, but also too, Mr. Speaker, in terms of the weather events that have happened for quite a while, it is important to remember it wasn't just the people that we lost through those tragedies, but also all the communities that have been affected by these weather events. And so this bill represents a very important step for New Zealanders throughout Aotearoa in terms of strengthening and understanding the pivotal points that when you're designing a framework, it's important to understand the differences of a community, but also the strengths that can be represented through an updated emergency management system. Mr. Speaker, I have a personal story because in the Auckland anniversary events, we were in a car and the whole motorway got flooded. There was chaos. It was a Friday evening and people just did not know what to do. And in my local community in Mangere, it was absolutely chaos because the flood waters were rising on the roads and many families were affected. It was before 6 p.m. that evening. People were coming home, picking up children. It was just absolutely chaos. And in that specific Friday event, who we had just left Hoani Waititi Tangi at a marae, it was a scary time for many citizens who were going about a Friday evening and then bang, the torrential rains. It was a very scary time. If I reflect back at that time, my immediate thoughts is, what is our emergency management system? Cell phones were not going, the flood waters were rising. It was a very scary time. And I was thinking about our elderly, our non-able-bodied community members. It was a very, very scary time. So I do want to acknowledge all the first responders. People were checking their phones. We were trying to reach family members. It is really important that citizens in our community understand the readiness and the response. So I want to acknowledge everyone that has been through. We have lost New Zealanders. We actually lost 15 New Zealanders through those events. And so through those difficult times, what are the lessons and who is responsible in providing specific leadership, either in a central government capacity or a local government capacity? When we're thinking about emergency management, one of the things, and Tulo, respectfully, we immediately think that everyone speaks English. We don't think about our matuas, we don't think about our citizens where English is their second or third or fourth language. And when we are interpreting, when we are designing frameworks, it is important that those who are contributing keep different nationalities and ethnicities in mind, but also the ages. Not everyone, not our citizens are all going to understand the instructions that come out either on your device or on paper, what is important. So I'll just move to the last points that I wanted to make. It's important that we reflect back on personal stories, but we get this right. I really appreciate the bipartisan and approach in terms of acknowledging those. And lastly, I want to focus on the role of iwi Māori. In every tragedy or circumstance that has happened, specifically in Māngere, specifically in South Auckland, iwi Māori have always been there. They don't come to or reflect on, we want this. They just say, here we are, this is what we need to do. I want to emphasise and focus the importance of their role in every or any planning committee in a community. I also want to make sure that the leadership and clarity for iwi Māori is understood in the framework. I commend the bill to the House.
Tom Rutherford.
Many people today have traversed the content of the legislation, so I actually want to spend just a brief moment actually acknowledging the leadership of the Minister himself. A really humble, diligent, hard-working Minister who won't want people to point out what he does in his role. But the first thing he does in states of emergency is get there on the ground, be with the people, hear them, listen to them, spend time with them. 19, I think it's 19 this term, and he has been there for all of them, and he has provided exceptional leadership on the ground, relatability, understanding the situation, and he has used that to be reflective in this legislation. And I think he has done a superb job, so I want to put on record our thanks to him for his incredible work. I commend it to the House.
Kushna Tamlana Manuel.
Tēnā koe e te māngai o te whare. O tira tēnā tātou katoa e mahi tahi ana mo tēnei pire. Ka tautoko awau I ngā mihi ki a rātou kua wehi atu, a rā ki a Rochelle, me ngā mea I hinga I roto I a Gabriel. Nā reira, hoki mai kia tātou te hunga ora, tihei mauri ora. I want to support the mihi to you, e te minita, for your proactivity during these times, and I have had the pleasure of being on the ground with you. Pleasure might be the wrong word, and I appreciate you and your staff as our wonderful spokesperson for this kaupapa, Camilla, has acknowledged, for including us and keeping us informed. I don't know if you're trying to make sure our emergency responders are so well prepared by creating all these disasters, but tēnei te miha te kia koe. Mr. Speaker, there's so much I could say on this, so I will try and encapsulate it to one focus, and that is the value of local. When Gabriel hit us in Te Tai Rāwhiti, we were ready to go, because through not only our nature, but through COVID, Hapu had gathered, Hapu had organised, so we had teams on the ground in every community ready to go, ready to work with whichever organisation we had to, and indeed lead them because of the local knowledge. And I want to acknowledge everyone here who appreciate the value of iwi and marae. But I want to talk about what that really actually means on the ground. Recently, Camilla and I went to Uawa, and like all our communities, they had opened their doors. And I must acknowledge Pene Brown, who described to the then Minister, Grant Robertson, their response in Te Karaka. He said, our response was threefold: our people, other Māori, and everyone else. And so when people open their marae, the impact is not just, hey, we're providing 4 walls and a roof. The impact is that these people, also volunteers, have to go to work in the morning. They're still worried about other waters going to breach. Where do we go to? There's no roads. The impact is we're taking a resource out of the community. That marae is no longer available for 21sts, for weddings, for tangihanga even. So I think we need to take a deeper look at what we're talking about when we talk about iwi and marae responsibility. So on that note, there's so many acknowledgements I could make. And one, of course, is maha ki tia ki tangata. Te Karaka was so badly impacted by Cyclone Gabriel. And one of the things we've learnt from that is while councils, etc., who do a great job, have monitoring devices, have technology, the reality is sometimes those cameras are about half an hour behind the local monitoring. So we've got people who actually stand by and go and man their rivers, monitor the levels, and then inform the councils and see them. So this is the true depth of iwi and marae input. And so while I acknowledge, I think we have to go beyond advising and embrace more leading, because it was my work on this that really made me determined that Māori have to go from being the response to the decision makers. And so thank you, Minister, for the advance we're making, and we can certainly go further. I want to thank Mr Foster for acknowledging the investment that Labor made in the response through the PGF. Tēnā koe hoa. And acknowledge that that's another positive thing that's come out of this, is the level of resource in our communities. I've talked about Te Karaka, I want to talk about Tokomaru Bay and all our communities, Hauiti, who now have fantastic resources beyond the people. At the end of the day, the best resource we have in our communities are our people, but now they have physical tools in our communities. And I want to thank Ben Green and all the other amazing CEDM workers across New Zealand who are going into our communities and upskilling our people even further. Because we support this bill because at its heart, it's about manaaki. It's about looking after people. And the investment that's being made and that will continue to be made will make sure we have resources and even more skills and resilience to continue to care for our communities. I commend this bill to the House.
The Honourable Minister Lee.
Thank you. Thank you, Mr. Speaker. I'd like to first of all start off by my acknowledgement to my learned colleague, Honourable Mark Mitchell, who has done an amazing job in this portfolio, and I thank him for this bill that's actually come to the House. This bill, apart from everything else that other members have actually said, this bill formalises and clarifies the concept of lead agency. I think that's a wonderful thing. And it reduces the ambiguity and clarifies who is actually making the decision so everybody knows who to follow. And this actually takes me to about 11 years ago. It didn't happen in New Zealand, it happened in South Korea, where a ship called Sewol sank, and 304 people died as a result, and 250 of the dead were students who were actually on a school excursion. That's 82% of the total who actually died. Out of the 172 who actually survived, more than half were rescued only by fishing boats that were actually nearby, and the Coast Guards were 40 minutes behind them. And the reason why that happened was no one actually knew who was in charge. There was no leadership. They did not know if the National Guards were in charge or the Coast Guards were in charge or the military could actually go and help. Even a foreign vessel, an American naval ship, was actually nearby and wanting to provide help, but they weren't allowed because they were foreign ship. And they could not actually help those children. And that is an utter disaster that I hope it never, ever happens in any other country. I commend this bill, which will make sure that it doesn't happen.
The question is that the motion be agreed to. All those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Emergency Management Bill number 2, first reading.
The question is that the Emergency Management Bill number 2 be considered by the Governance and Administration Committee. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Mr. Speaker.
The Honourable Nicole McKee.
Mr. Speaker, I present a legislative statement on the Arms Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website.
Thank you, Mr. Speaker. I move that the Arms Bill now be read a first time, and I nominate the Justice Select Committee to consider the bill. Mr. Speaker, over 40 years ago, Parliament enacted the Arms Act 1983. Since then, politicians have spent 40 years amending and rejigging the Arms Act 1983. Each change made was stacked on top of the next, rushed through in moments of political panic or patch-ups, until what's left is a law that is confusing for licensed firearm owners, inefficient for police, and ineffective at stopping criminals. New Zealand deserves better. Mr. Speaker, public safety and respect for licensed firearm owners are not in conflict. They actually depend on each other. This bill starts with that simple premise. It rewrites the Arms Act in plain English with logical structure and practical improvements. The result is stronger firearm laws that better protects the public and a simpler regulatory system that supports compliance. Mr. Speaker, the tragedy of 15 March 2019 was a day of unimaginable horror for this entire country, and none of us want to see that again. But the arms laws that followed were rushed, confused, unfair, and they punished the wrong people. They targeted the responsible, law-abiding New Zealanders instead of checking the systems and processes that led to this country's worst atrocity. They even negated really targeting criminals and gangs when they made their changes. Good law is not made in a panic. It's made with clear heads, sound evidence, and respect for those who already do the right thing. That is what this bill does. Mr. Speaker, a core lesson from the past decade is that trust matters. For law to work, the public must have confidence in the system administering it. This bill creates a new independent firearms regulator to replace the Police Firearms Safety Authority. Its job will be to regulate clearly, consistently and transparently so that licensed firearm owners can comply without unnecessary burdens. It will operate independently of New Zealand Police, with an independent chief executive, and no sworn police officers will work within it. Police will retain all the information that they need for enforcement, but their focus can shift to where it should be, pursuing the gangs and criminals who put the public at risk. The regulator will be empowered to provide clear guidance in consultation with the firearms community, so licensed firearm owners understand their requirements and can comply with their obligations. This bill also sets clear limits on what information can and cannot be recorded in the firearms registry, promoting transparency and building public confidence. Mr. Speaker, I've heard the concerns about licensing delays, and this bill helps them. When New Zealand moved from lifetime firearm licences to 10-year licences, tens of thousands of people moved into the 10-year system all at once. So every decade since, the same surge and bottleneck has repeated for the same people. To put this into context, in a normal year, there are around 9,000 firearms licence renewals. This year, we are expecting around 55,000, and next year there will be around 50,000 renewals. To smooth this out, the regulator will have the discretion to be able to extend firearm licences for up to 3 years for some licensed owners whose renewals fall during the peak periods. Over time, this will end the bottleneck cycles each decade and create a steadier, more manageable flow of renewals. The regulator will also be able to issue infringement notices and educate licence holders for lower level offences, rather than revoking a licence as the only option. This keeps people in the system and learning, instead of pushing them out for behaviour that does not pose significant risk. Health-related suspensions are introduced and could last up to 12 months. Under the current law, many people lose their licence permanently simply because they needed more time to get help. That is neither fair nor proportionate. If a licence applicant disagrees with the regulator's licensing decision, a new independent firearms licensing review committee will hear their appeal. It replaces the current internal police-run process with a truly independent panel consisting of a lawyer, a representative from the firearms community, and an appointee of the regulator. Between October 2021 and March 2025, a third of appeals in the District Court resulted in a different outcome, showing exactly why this change is needed. The current Act, Mr Speaker, is not fit for purpose for people whose work or expertise requires specialised use of firearms. Pest controllers and biosecurity organisations perform essential work protecting our environment and agricultural community and economy. Their endorsements will be extended from 2.5 years to 5 years with a mid-term check-in. Multi-user agreements will allow restricted firearms to be temporarily transferred among approved pest control employees for up to 7 days without triggering unnecessary paperwork. Dealer licences will be renamed business licences to reflect the variety of modern firearms-related businesses we have. Compliant holders will have their licence duration extended from 1 year to 5 years, directly addressing one of the most frequent complaints that I have heard. Business employees will no longer require endorsements on their personal licences, subject to controls being in place. And gunsmiths will be able to conduct short-term repairs on restricted firearms without a permit to possess. Import permits will be extended from 30 days to 12 months, reducing administrative burden for both businesses and the regulator. New licence classes have been introduced for museum curators and their employees to reflect their unique circumstances, ensuring their rules are not disproportionate or so costly that they have to shut down. Collectors will also have greater flexibility around where the vital parts of a prohibited firearm must be stored. Mr Speaker, if we want to improve public safety, we must ask, who is driving the offending in New Zealand? And the answer, overwhelmingly, is criminal gangs. Gang members represent less than 1% of New Zealand's population, but are linked to around a quarter of all firearms offending. And this bill deals with that directly. It introduces automatic disqualification for gang members from holding a firearms licence, new offences for straw purchasing and diversion, offences to tackle 3D printed firearms made by unlicensed individuals in possession of digital files used for illegal manufacture, and significantly increases penalties for over 60 offences. Many have been untouched since 1983. This bill also clarifies product definitions, rules around manufacturing, and closes loopholes relating to large capacity pistol magazines and blank firing guns. For individuals who inadvertently find themselves in unlawful possession of a firearm, there are clear pathways now back into lawful ownership. One of the simplest and most important improvements is allowing secure storage at any regulator-approved location, not just a primary residence. Students that live in halls, renters, and many other people who were simply unable to meet the secure storage requirements will now have a safer choice for security. Mr Speaker, this bill balances safety, fairness, and practicality. It strengthens the law where criminals exploit it, and it simplifies it where licensed firearm owners have been burdened by it. It's not a bill that scapegoats legitimate firearm owners. It's a bill that fixes what matters. I encourage all New Zealanders to participate in the Select Committee process, especially those who will be impacted by this law. Consultation informed this law, showing that more voices make better law. This government values the vital role that farmers, hunters, sports shooters, pest controllers, dealers, museums, collectors, gunsmiths, and all licensed firearm owners play in our economy, our environment, and in our heritage. This bill is for them. And Mr Speaker, I'd just like to acknowledge that one of my staffers that has been working on this bill with me for the last 2 years is having his birthday today. Happy birthday, Matthew O'Connor. I now commend this bill to the House.
The question is that the motion be agreed to.
Mr Speaker.
The Honourable Jenny Anderson.
Kia ora, Mr Speaker. Thank you for the opportunity to speak on this bill, the Arms Bill. This bill is a major retreat by Nicole McKee from what was originally threatened or promised. But this is a major win for public safety in New Zealand. What was initially meant to be in this bill was enabling military-style semi-automatic weapons to be used on a gun range, that the Firearms Safety Authority would be taken out of New Zealand Police and the Firearms Registry would be changed to exclude weapons such as A category firearms. None of those things are in this bill, and that makes New Zealand a safer place. The fact that I held public meetings in Auckland, Wellington and in Christchurch on the risks of deregulating military-style semi-automatic weapons, that we ran a petition that got numerous signatures, that media engaged, that New Zealanders made it very clear that we did not want prohibited weapons, military-style semi-automatic weapons that were used in the Christchurch massacre made more readily available in New Zealand. And it is heartening that that those voices were heard loud and clear, and that this bill does not make that dangerous change. I know there are many members of the Muslim community in New Zealand who will be grateful to see that that change has not been made. The Firearms Safety Authority also will remain in